Vivian Walker versus Buck Bay Limited. Okay, ready?
Sure.
You argued the other case.
They would not want me to do that. May it please the court, my name is Natalie Maxwell. I'm joined by my co-counsel Gloria Walker at the table. I represent the appellants. I'm requesting 3 minutes for rebuttal. This action centers around a contractual dispute between appellants who are residents of a mobile home park who own their mobile homes, and appellees who are the former owners of the mobile home park. This issue comes to the court on the granting of defendants' appellees' motion to dismiss counts 1 through 3. While we made several points in our briefs to the court this morning, I would like to focus on 3 points. The first is that appellant's right of first refusal is not defeated as a matter of law by including the property to which there is a right of first refusal in the sale of multiple properties. The second point that I would like to address this morning is that the language of the contract here, the specific right of first refusal being that the court is being asked to interpret, that the sale of the mobile home park did in fact trigger that right of first refusal. And the third point that I would like to make this morning is that the dismissal with prejudice of counts 1 through 3 in this case was unwarranted.
If it did trigger the right of first refusal, what is the price that your client would have to pay to exercise that right?
Your Honor, in this case, we're seeking damages, and so this is not an action for specific performance. Other courts that have looked at the issue of specific performance have determined that the price for the right of first refusal in some cases could not be determined, in which, however, there was a remedy at law due to the fact that there was a right of first refusal on the single property and it was included for sale. Other courts, none within our specific jurisdiction, have concluded that the price can be determined by what the property was sold for, and that is what is pled in the complaint.
Now, assuming that Buck Bay Limited is stock, ultimately there's some stock somewhere that expresses the ownership, and all that stock is owned by one individual, and that one individual were to die and his will left the stock to somebody else, does that trigger the right of first refusal?
Your Honor, I believe that if the right of first refusal is only triggered if the property is offered for sale while the tenants reside at the park. So if there was a case where someone had passed and the property passed pursuant, then in fact the right of first refusal would have been triggered. And as a matter of fact, there was a case with similar facts in which the court found that the right of first refusal was triggered in those facts. However, that is not the case here. The fact of the matter is that the owners of the park who drafted the prospectus were not required to put language regarding the right of first refusal into the prospectus by the Florida Mobile Home Act, but chose to do so, which in part recognizes the fact that the relationship between a mobile home park owner and the residents of the mobile home who lease lots is not the same as a traditional landlord-tenant relationship. In this case, both parties have a property interest. The tenants have an interest in their mobile homes which they own, and the park owner had a property interest in the mobile home park which they owned. And in order to address the property interests of both of those entities, the Florida Mobile Home Act was passed, which is what requires that there be a prospectus given to the tenants when they move into the mobile home park. And that prospectus also includes their lease agreement.
And that prospectus, though, refers to the sale of individual lots, correct?
No, Your Honor. If I may read the language, the relevant language from the prospectus, it states that the owners of Buck Bay reserve the right to sell any or all of the lots within Buck Bay at any time subject to the notice requirements set forth below. And the notice requirements, as previously discussed, apply to lots that are occupied by a tenant's mobile home. So there's no language in this prospectus at all about that differentiates between the sale of an individual lot as opposed to the sale of the entire mobile home park, which is what appellees are arguing. Instead, if you look at the plain language of this prospectus, it clearly contemplates the sale of individual mobile home lots by themselves or as part of the sale of the entire mobile home park.
One of your cases that you cite where there was a first refusal given, and then when the sale was made, they added other parcels to the parcel that had the right of first refusal, correct?
That's correct.
I mean, here we don't have, this is one parcel.
No, Your Honor. While the appellees claim that this is a mobile home park, when it's convenient for them. In this case, there's language in the prospectus in the zoning provision that says that it's not zoned as a mobile home park for purposes of zoning. In fact, the lots are platted individually as 144 lots. And the language in the right of first refusal in this case is what governs. While those other cases are instructive on the issue of whether, as a matter of law, the right of first refusal applies to a single parcel of property when it is included in the sale of other properties, in all of those cases, the court's analysis begins with the language of the contract. And in this case, the language of the contract is clear that it's the sale of any or all of the lots. And when appellees sold Buck Bay Mobile Home Park, they in fact sold any or all of the lots.
Counsel, this case was disposed of by the trial court on a motion to dismiss.
That's correct, Your Honor.
Never made a summary judgment.
I'm sorry.
The case never made it to summary judgment.
This case never made its summary judgment, so all the facts have not been determined. Now, this case, we are just at the pleading stage.
Before you complained, was a copy of the contract prospectus attached to the complaint?
Yes, Your Honor. And on the motion to dismiss, the court is only looking at whether the complaint sufficiently states a cause of action under the claims. And in doing that, the court is restricted to the four corners of the complaint and the attachments to the complaint. The court must accept plaintiff's allegations as true, and the court must resolve all inferences in favor of the plaintiffs.
Now, the form of ownership didn't change from the time your clients rented until the time Buck Bay transferred ownership, did it?
No, Your Honor. Not as far as we can tell without having developed the facts.
If they had a mortgage on the property and then they had not paid the mortgage payment and the bank were to foreclose, obviously that would be a change of ownership and it would be against the whole parcel. Would that trigger the right of first refusal?
Well, Your Honor, going back to the language, the right of first refusal was only triggered with the sale of the property. So if...
Well, the sale of the lots, any or all of the lots. And you're saying because they sold everything, common areas and the lots, and they sold their whole business, in essence, that triggered because that would be all.
Correct, Your Honor.
Of lots, plus more, but always that plus was included. And I'm just wondering if any transfer of ownership, because obviously I mentioned the state laws, it could have been given away, stock could have been sold, there could have been a mortgage on it and foreclosed. And I'm just wondering if these kinds of events would also trigger your client's right to purchase their lot.
Based on the language of this prospectus, it would. The language is that it's the sale of any or all. So in the example of foreclosure, if the bank is going to sell the lots before it can sell them to the general public, the lots that are occupied. So it's not each and every one of the lots, presuming those lots are not occupied. It's just lots that are occupied by the tenant's home. And as I was explaining earlier, the reason for that is that the property interest in a mobile home park is different than other types of landlord-tenant relationships, because both the property owner of the mobile home park and the mobile home owner have property interests.
Counsel, is it your position that interpretation of the language, all of the lots, whether that is the same as the entire division, is a question of fact that should not be resolved on a motion to dismiss?
No, Your Honor. My interpretation is that this is an issue, that this is a matter of law that could and properly be resolved on a motion to dismiss. Because it's a contractual language, it is proper for the court to determine what the meaning of that language is. And here, both the appellants and the appellees have agreed that this language is not ambiguous. It clearly states that in the cell of any or all the lots, and that is exactly what happened here.
Why assume the former owners? Why not the current owners? I mean, if the covenants continue, why the former owners on the hook and not, in other words, when I purchase Buck Bay Limited, I'm purchasing all these obligations, and either I need to give you your option to purchase your individual lot, or I need to pay the damages that you may be able to prove. But why the former owners?
Your Honor, both the former and the current owner of the park are being sued. However, the only claims that were dismissed were those related to the former owner.
So your lawsuit survives against the current owner?
Yes, Your Honor. In addition, the lawsuit against the current owner is based on a separate additional facts and actions that have occurred after the breach of contract that is being sued for here.
Because it was over 6 months, wasn't it, where absolutely nothing was different from the previous owner to the current owner, right? I mean, wasn't it, maybe it was about a year? I mean,
factually, that's correct, Your Honor, but that does not affect that the contract was breached. What happened after the breach of the contract is not relevant to whether or not the contract was breached. And here, by selling the lots without offering the appellant's notice, it is not that the appellees could not sell the park or that they couldn't sell the individual lots. They had every right to do so. What the right of first refusal did was it guaranteed the mobile home lot tenants that they would know about the sale so that they could then exercise their right of first refusal and essentially stay in their homes.
But we have unified ownership, and you're saying there's no difference between unified ownership and then really where you would have been is perhaps some of these tenants may have exercised their right, and so we would no longer have unified ownership. It wouldn't be a park owned by one entity that could have rules and standards and consistency or any of that kind of thing.
That is not necessarily true, Your Honor. I mean, that supposes the fact that people who would have exercised their right of first refusal would not have wanted to form some sort of homeowners association with additional owners in the park to allow for some sort of semblance of a community, which people do all the time in subdivisions where there is no obligation. Well, there may be a contractual obligation to form a homeowners association. And in the prospectus, there also was such language that a homeowners association needed to be formed before the property could be sold, and to be able to address that sort of concern. I'd like to reserve the rest of my time for rebuttal.
May it please the court, my name is Bruce Brashear. For simplicity's sake, I represent all of the defendants other than Edix, Inc., which is the subsequent purchaser of the mobile home park.
Counsel, let's see technicalities.
Yes, sir.
Can you sell all the lots without selling the entire development?
Sure. And that, of course, is the basis of our position.
So selling the entity is different than selling all the lots?
Selling the entity would be different than selling all the lots. Selling the mobile home park as a single unit is different than selling all the lots. I would invite the court to take a look, because this is really, I won't say simple, but it's a question of contract interpretation. And we have no disagreement that this prospectus, in effect, became a contract between the people that were entered into these one-year leases. And I think it's important to remember what the relationship is here. The plaintiffs moved their mobile homes onto my client's property, or what was then my client's property. knowing that it was just a year-to-year lease. Part of the deal was this paragraph 11, which is headed zoning, but which includes the right of first refusal provision, if you will. And it says, Buck Bay is a platted mobile home subdivision. The individual lots can be sold. As far as zoning is concerned, Buck Bay is not a mobile home park. The owners of Buck Bay reserve the right to sell any and all of the lots within Buck Bay at any time, subject to the notice requirements set forth below. The lots that are occupied by a tenant's mobile home may not be sold without first giving the tenant 12 months written notice that the lot will be offered for sale, and the right to purchase the lot at any time during the 12 months for a plot price at 10% below the anticipated retail lot price. If the tenant does not exercise his option to purchase the lot, he must remove his mobile home from the lot at the end of the 12-month period, which begins when the tenant is notified the lot will be offered for sale. Our position is that this language is unambiguous, and I believe that it's conceded in appellant's brief that, in fact, it is unambiguous.
You couldn't have sold me 10 of the lots without triggering that event.
Absolutely. Really what is going on here is two different business models. You can have basically, to use the apartment analogy, you can have an apartment building and rent out all the apartments. Or you could turn it into a sort of condo and you could sell each individual lot. And my clients, when they set this up, wanted to leave the option to do that. They still could have remained owners and sold out the individual lots, not unlike selling out lots in a subdivision. In fact, pretty much the same thing. I would point out that there was never any separate owners association to own the common areas, that the whole parcel was owned by a single entity.
Well, your analogy to apartment condo is interesting, but it fails. I mean, if in fact, if we take your analogy a little further, you had all the paperwork done, all the condo documents drawn, and you in fact had a condominium, except you owned all the units, and then you sold all the units to someone else, wouldn't that trigger
In this case, by analogy, if my client had started selling condominium units, that's exactly the kind of thing that is contemplated by this right.
But by their zoning, they had kept the right to sell these as individual
units.
I mean, so, I mean, not that it was condo, but in the apartment complex, you can't sell an individual
unless you change.
And that's a process, it costs money, time, and all that. But assuming that, I was trying to say your client is already there, where he could get up in the morning, could have gotten up in the morning and said, you know what, I'm tired of this, I want to sell the lots.
Yes, sir.
I think that would be better for us in the long term than renting them.
Okay.
Instead, he sold all of them.
Well,
So if your client has sold all the lots, but maintained control over the common area, then would that have triggered the notice provision?
Yes, sir. I think that's a different situation, but that's not the facts as pled in the Third Amendment complaint. Exhibit D to the Third Amendment complaint contains a sales contract. There's only one legal description in here.
There's no provision in the contract that says that the owner may sell the subdivision or the division or the development and not be required to give notice to individuals.
It doesn't say that, Your Honor.
But it does say if the owner sells all the lots, then it triggers the notice provision.
All the lots at retail, I think one always has to interpret a contract and read all of the relevant provision in there. Remember, too, that...
Couldn't the drafter say the owner retains the right to sell the entire development without giving notice to the individual?
If I could get into a time machine and go fix this, I absolutely would put that in there.
But you did provide that if the owner sells all the lots, then it triggers the notice provision.
Well, sell lots as opposed to sell the park as a whole, I think, is the distinction that's quite clear. Because one of the requirements here, in order to trigger this right of first refusal or option, whichever way you want to look at it, is to have an anticipated retail lot price for each lot. You don't have that here, and it's not alleged here because you can't. What they've done is taken the whole price and divided it up by lot. It's not the same thing.
Well, I mean, what if your client said, you know what, I want to sell the lots, I don't want to mess with my current tenants. I don't want to mess with a 10% discount, whatever. So I will transfer all the lots over to another entity.
So the hypothetical would be that you have severed the ownership of the lots, but not the common areas. And of course, that's not the facts that we have, but I think that would be a much closer case than what we have.
I wonder if they had kept one lot, just one lot. Their son was on one of the lots they kept.
I don't think that would change anything, because under those
They
situations,
wouldn't have sold the entity.
well, again, it's not the facts that we have, but if they had, the trigger here is parceling out these lots, and the language, I think, makes it very clear.
Is it dispositive if there's only one legal description?
Well, I think that's one of the things that the court can consider, because there's nothing at all in that sales contract about the sale or mention of these lots. It's the whole part and parcel of the mobile home park. Clearly a different thing. We talked.
Was your client able to provide the 12-month notice?
Well, I hesitate because I don't recall what's in. I think this is in the pleading, Your Honor, that in fact the tenants have been in there much more than a year past the sale date. I know that to be true. And so from that, yes, the time between when the transaction began and when it closed was not a year. If I may address a couple of things, we talked about the retail price. I think that is important. I would ask the court, direct the court to paragraph 81 of the third amended complaint, wherein it illustrates that the plaintiffs know how to allege the sale of individual lots because, in point of fact, the subsequent purchaser intends to sell the lots individually. That's why he bought it. There's an economic benefit to, it's like parting out a car or something. It's worth more in pieces maybe than it is as a going concern, but there's some work involved. Paragraph 81 says defendant edicts intends to offer individual lots to sell to the public. That would trigger it. I think one of the very important things here to keep in mind, and this also...
So you'll have to respect this provision.
Sir?
You'll have to respect or honor this provision.
Yes, sir, and that was the point that I was going to make. The moment before the closing of the sale to edicts and the moment after the sale to edicts, all of these plaintiffs had exactly the same rights. Unlike the cases that are cited for the right of first refusal or the options, where you have one parcel and then you bundle it with another and you try to get around the right of first refusal, that would have take away a right that those people had, the plaintiffs in those cases. In this case, nothing was taken away. As the court has noted, the real problem here is with edicts, if there is a problem at all, and not with my client. I will just mention also there is a count, I think it's count 3, that references section 723.017. The arguments we've just been talking about interpretation apply to all 3 counts that were dismissed. Because if there's not a breach of this right of first refusal, there's no violation of any of the statute. But this particular statute requires that there be a publication of a false statement, and also requires that it be done under the authority of the park owner or developer. Neither of those exist in this case. If there are no further questions,
Counsel, this is a practical matter. What is left of the development after all the lots are sold?
well, if one were to sell the lots at retail, then as a practical matter, one would have to find a mechanism to allow the common areas to accrue to the benefit, of the lot owners.
Are there common areas?
Yes, sir, but that's the point I was making before. They were owned at the time of the sale by the single entity, Buck Bay. It wasn't as though you would have the subdivision where you had an owners association that would take title to the common areas and have an obligation to keep it up and so on. And if this retail lot approach to things, if that had taken place, then no doubt steps like that would have had to occur. But
So I sold all my lots, and not be required to comply with notice provisions. But if I sell all my lots in the common areas, excuse me, if I sell all my lots in the common areas, I don't have to comply with the notice provisions.
Well,
but if I sell all the lots, not the common areas, then I have to comply with the notice provisions.
And I would answer this maybe, Your Honor. The answer is that if what you were selling is retail lots, you have someone.
But does that really the tenant's rights under the effective means?
Well, I think it's very clear what it means. The tenant is on a piece of property, and should the owner ever decide to sell lots individually, in other words, to allow them to buy that square, then they have first rights to it. But there's nothing in there, as you point out. I wish there were, but I think it's not what is triggered by this language. That then they have a right to stay where they are. Otherwise, not. One should keep in mind that the park could have been closed, and done it without any violation of this, and then resold. There are a lot of other things that could happen. Focusing on the fact that all the lots are sold, I think under the circumstances, and given the fact that it's clearly a sale of the whole operating entity, and let's remember, too, that all these leases remained in effect the day after the closing, and what the buyer was buying was a mobile home park with tenants. It's simply not triggered. This transaction did not trigger the right of first refusal. If there are no further questions, I'll sit down.
Thank you.
May it please the court, the appellee's argument that the sale was not triggered because the entirety of the park was sold, that the right of first refusal was not triggered because the entirety of the park was sold, and grabs new language into the contract. The clear, plain language of the contract is that the sale of any or all lots. It is not any or all lots except if those lots are sold with the common areas. It is not any or all lots with any exceptions except that the lots be occupied by a tenant's mobile home. In addition, with regard to whether as a matter of law the right of first refusal is defeated, the Second District Court of Appeals in Wyhopen versus Villa, while they did not address this issue directly, relied on dicta in Danko versus Bell to hold that the tenant there who had a right of first refusal to a single property could exercise that right of first refusal even though that single piece of land was being sold with additional property. So in this case, applying the reasoning in Wyhopen and taking into account the dicta in Danko, the equity here is that the appellants had a right of first refusal. And for that reason, appellants seek that this court reverse the trial court's decision that that those counts be dismissed with prejudice, that the court instruct, or in this case hold, because this court can review de novo, that the right of first refusal in this case, given these facts, was triggered by the sale of the park. Thank you, Your Honor.
Thank you, Your Honor.